Okay, so Karen Chaff. Hey, thank you all very much for coming on this Tuesday evening, which I know is not always the day of the week that you think about coming to such an event. So thank you very much. A very warm welcome to you all. We're delighted that you're here with us to hear from Joshua Rozenberg and our Question of Law Legal Advice Centre annual talk. It's our third talk, so we're really delighted to have been able to carry on that tradition. Before we start, I just want to say a few words about our law clinic, our legal advice centre. Hopefully you've seen our annual report and you'll be able to sort of flick through and see what we get up to. Of course, it is a centre for advice, but really more importantly, it's a place or a space where our students can actually deal with real problems and help real people. And we are, on that note, really grateful to our pro bono solicitor volunteers, who many are here today: Amanda Timke, Paul Whittingham. I'm sure Ben Hargraves is here. I haven't managed to see him yet. But yeah, really very grateful for the support they give, because we wouldn't be able to carry out that work without them. And I should also mention Burkitt Solicitors in that, because there are several lawyers there that help us. So thank you very much for that. The other thing I briefly wanted to mention is, why did we ask Joshua Rozenberg to come and talk to us today? Why Joshua? You know, he's very regretting the decision now. Obviously, we had Baroness Hale at our first lecture, and Sir Brian Levison last year. So the reason that Joshua Rozenberg is here is because that is what our students asked for. And every year, this is how we do it. So the previous year, Emily Lark, another student, she asked to hear from Sir Brian Levison, and this year was a resounding Joshua Rozenberg. And why is that? That's probably because he does amazing Law in Action podcasts, and they're available on BBC Archive. So if you've never listened to them, I really urge you to do that. But our students are aware of those, because in their first year, in their first module of their first year, it's part of the curriculum. So we sort of handpick a few kind of interesting topics for them to listen to Joshua Rozenberg talk about, and then we sort of debate them in class. And those sort of early sessions are some of the students' favourites. So I think they really have inspired our students. Of course, what it shows is Joshua's unique ability to translate complex legal subjects into plain English. So it's a form of public legal education, which is super important, and hopefully our lecture today acts as that too, because I know we have many members of the public here today, in addition to our students and lawyers as well. So that is why Joshua's here, and I'm looking forward to hearing his insights. So that's all I wanted to say, really. I'm just going to hand it over to Amanda Timke, who's the Education and Training Officer for Suffolk and North Essex Law Society, just to say a few words, and then David will introduce Joshua. So thank you.
Thank you for the introduction. That's okay. Yes, I'm not really good enough for the president of the society at the moment, but I am part of the president of the Law Society. So if you have any questions about the organisation, please speak to me afterwards, or your colleagues like to me if you're in the audience, or the past president. But I wanted to say, when I qualified as a solicitor myself in 2003. The legal landscape was evolving quite rapidly then, and it was long before such a strong cohort of female potential solicitors came into the profession. But it was a time when understanding law wasn't really what we completely needed to deal with. We needed to master not just statutes and case law, but also appreciate how law interacts with society. And Joshua did actually play a pivotal role in shaping that perspective for me, even though law in action was way before my time. But it does show that it creates a wider lens in which a role of a solicitor or a legal executive, a paralegal, there's so many different routes into the legal profession nowadays, embodies the fact that we are not just providing access to justice, but we are ensuring that we can communicate and make what is a very complex, often, area and language into things that people can understand, and so that they can fight themselves for their freedoms, their rights and their liberties. Joshua's emphasis on transparency and integrity reinforces actually what, as a solicitor, I try and do every day and how I try to lead my team. It really has underpinned what the ethics of professionalism is all about as a solicitor. I'm going to just cut across here for our bits. I can't finish by not saying that the Suffolk and North Essex Law Society is honoured to be here supporting again for the third year running this wonderful annual lecture, which brings about various people from our communities into the same room. It is an opportunity to champion clarity, integrity and accessibility in our local legal community. Together, we must ensure that the law continues to serve every aspect of our communities. And again, I really do say a big plea to all of law firms and organisations which promote the practice of law in whichever guise to come together and support each other through the Law Society. We can then represent you better and make differences in how you make your clients feel and how your clients receive your services. Thank you.
Hello, my name is David James. I'm head of business and law here at the University of Suffolk. I just wanted to say a few words. First of all, welcome to the University of Suffolk and a question of law and evening with Joshua Rozenberg, brought to us by the University of Suffolk Legal Advice Centre in partnership with Suffolk and North East Essex Law Society and Ellison's, of course. So it's wonderful to see such a strong turnout this evening, colleagues from the local and regional law firms, students, staff from the university and members of the public who share our interest in law and justice. So this event embodies the idea that legal education should be accessible to everyone, not just those from the profession. And this evening we have the privilege of hearing from Joshua Rozenberg, Britain's most experienced legal commentator. So Joshua trained as a solicitor, qualifying in the mid-70s, but chose journalism over practice, a decision that has allowed him to combine legal expertise with excellent communication skills, and this unique position allows him to do something vital for our democracy. So the philosopher Jürgen Habermas argues that democracy isn't just about voting. It's about what he called deliberative democracy, where legitimacy comes from citizens reasoning together through public debate. People need spaces where they can freely discuss, argue and form opinions to enforce a better argument rather than manipulation or power. Habermas called this the public sphere. But deliberative democracy only works when certain freedoms are protected by law. So freedom of expression, freedom of the press, freedom of assembly, and these are the foundation that makes democratic debate possible. This is where the journalism of Joshua Rozenberg becomes essential. He doesn't tell us what the law should be, that's for Parliament and the courts. Instead, he explains how judges reason, how legal principles develop, why cases matter. He makes the law accessible so we can all participate in informed debate about justice and the rule of law. Joshua Rozenberg has spent a life in legal journalism, honing his ability to communicate across the last 4 decades from the BBC, where he launched Law in Action in 1984, to legal affairs editor of the Daily Telegraph, later writing for The Guardian and the Evening Standard, as well as the Law Society Gazette twice monthly since 2008. But what's particularly impressive is how he has embraced different media forms. He was on Twitter from 2011 until 2024, when he switched to Blue Sky. In 2020, he launched a Lawyer Writes on Substack, with usually daily updates providing an in-depth legal analysis and commentary. In 2024, he added a Lawyer Talks, a podcast featuring weekly interviews with leading legal figures. And Joshua continues to appear regularly on television and radio as a legal affairs analyst, and indeed was interviewed just before this lecture by a news outfit. Just as Joshua works to make the law accessible and understandable to the public through his writing and broadcasting, institutions like our Legal Advice Centre make the law accessible in practice. Access to justice and public legal education are essential parts of a functioning state based upon social justice and the rule of law. Tonight, Eleanor Scarlett, Director of the Legal Advice Centre, will be in conversation with Joshua, discussing his journalism and his relationship with the law and the commentary on the law. We're fortunate to have this opportunity to hear from somebody who spent a career interpreting the law for all of us, someone who understands that democracy depends not just on having laws, but on citizens who understand them. Please join me in welcoming Joshua Rozenberg.
So the first thing I'd like to mention is that there are a few people standing at the back. And there are many seats available just sort of on the third row from the back. So maybe it might be a good idea, because you probably don't want to stand for an hour. So just try and find somewhere to sit. And so Joshua, thank you very much for coming. The first question I really wanted to ask you about, I did in my welcome sort of briefly touch on Law in Action, and those podcasts have been really important to our law students, but maybe we should sort of reverse back a bit here and explain what those podcasts are. Perhaps you could sort of enlighten everybody to what Law in Action is.
Well, thank you very much, Eleanor. It's really what Law in Action was, I'm afraid. It was a radio program that started 41 years ago. It almost made it to its 40th anniversary. It was abolished by the BBC in the spring of last year. They have their own reasons for that. Some were explained to me, but I'm not completely convinced about it. I just did the program for the first 2.5 years, from 1984 to 1987. And I combined presenting this program for Radio 4 with writing, broadcasting, taking part in radio news coverage of the law. And then it all became too much. There was a case called Spycatcher in Australia, and I couldn't go to Australia and cover this case because I was stuck doing Law in Action every week. And after a while, the BBC decided that I couldn't do the radio program and write about law for news as well. So I gave the program up, and nearly 25 years later, they asked me back to do it. So your students will have listened to the programs that we did over the past decade or so. But as I say, the program ended. And it was at that time that I said I would do my own podcast, which, as you've heard, I launched last year. But it's not the traditional podcast. It's me interviewing lawyers and legal figures and so on. And that's one of the things I do on the Substack, which you very kindly mentioned, which is where I do most of my journalism these days.
And talking about Law in Action, and you founded that in the early 1980s, what prompted you to do that? Was it in relation to, furthering public legal education?
Yes, the BBC, there was a chair of the BBC, chair as we now say, chairman as he would have been called, in those days, who said to somebody senior in news, what are we doing about law then? You know, we ought to be doing something about law. It's quite important, isn't it? A lot of it about that sort of thing. And this chap, quick as a flash, said, oh yes, we're launching a legal program and we're going to recruit a legal correspondent, which I suspect he just thought of off the top of his head because there were no plans to do that. So they advertised for a legal correspondent, and the first rule of journalism is to be in the right place at the right time. And you know, many stories that I've benefited from and others, same sort of thing. And so, you know, I applied, and given that I had had a legal training and had by then qualified as a journalist, and given that I'd had a journalistic training, I qualified as a solicitor and had a journalistic training as well, I was the obvious person to do this. And so I became their first legal affairs reporter. This was at the time of the great miners' strike. We're all far too young to remember that. In the 1980s, mid-1980s, and there was a lot of law involved in the miners' strike. And then they decided this was quite a useful thing, and they confirmed me in my appointment as legal affairs correspondent, and then the miners' strike came to an end. But there was still a certain amount of law to cover. And as I say, I did Law in Action for a little longer, and the program carried on. Marcel Berlins presented it for a very long time, excellent presenter, no longer with us.
And then it's right that you then went back to Law in Action.
Yeah, because again, he gave it up, and then there was another presenter, and then the BBC decided that they would give him up. And in the classic way, I mean, he took me out to lunch once and said, look, I hope you don't mind, you're doing a certain amount of freelance work for the BBC in news. And I've got a contract with News to do a little bit of freelance work for them. So I hope you don't mind if I'm taking the bread out of your mouth. And I said, absolutely fine, no problem at all. You do know that they've asked me to do Law in Action. And of course, he was the last to be told. You know, it had been decided, I'd been asked, everybody knew but him, and that's how the BBC worked. And he never spoke to me again.
Oh dear. Oh, well, so talking about Law in Action, just rewinding slightly, you mentioned that you trained and qualified as a solicitor and then moved to journalism. What prompted that move after going through the pain of training and qualifying?
It was pain. No, because I didn't actually get through the Law Society's exams until after I joined the BBC. What prompted it was a friend who happened to work in the BBC appointments department in a secretarial job. And she came round with her husband to tea, and she mentioned to my wife, who was then training as a journalist, that the BBC was looking for trainee journalists, and said to my wife, would you be interested in applying for this? Because she had seen the jobs advertised. I mean, as I say, she was in an administrative job in the appointments department. And my wife said that she had no particular interest in broadcasting, and she was perfectly happy training in newspapers. And then somebody, and it was either this friend of ours or probably my wife, said to me, why don't you apply? And it all sounded rather glamorous and exciting. It said, candidates will be required to take a voice test. And that seemed, you know, I didn't know what a voice test was, but I thought I could probably speak, and you know, that seemed to be required. And I applied, and because, and this is a lesson for students, there is a point to this story, because it was 2 or 3 years after I'd left university, and because I had done something since university, that is to say, training as a solicitor, it meant that, you know, when my application came in, it stood out from all the others, and there were hundreds of people who just left university and thought that journalism was something worth doing and something they could do. And the point was, I had a skill to offer. And the very wise man who was running the journalist training scheme at the time thought that at some point in the future, the BBC might actually benefit from somebody with a legal training who might also be trained in journalism. And although that took another 10 years, that proved to be the case. But the point was that, you know, to my complete surprise, having gone in for the voice test, which was easy, and the journalism test, which was much more difficult, but because my wife had been training in journalism at the time, she came home and told me what was required, and I picked it up from her. And so I got through all of that, and then they said, do you want this job as a trainee journalist? And that was a very difficult decision in a way, because there I was, a solicitor's article clerk, as we used to call them, and my future was assured. It wasn't very interesting, but it was assured and planned, and it would have been fairly clear. And do I throw it all up and join the BBC? And the guiding principle was and remains: if somebody offers you something, take it. Because if not, you'll always regret it. I mean, you might regret it if you take it, but at least you won't say, well, what would have happened if I'd taken it?
Yeah.
You will know what happened. I did the same thing when I left the BBC and joined the Daily Telegraph, which was a slightly less successful move, but nevertheless, the principle was, take things when they're offered, and see what happens. And if they go wrong, they go wrong, but you're never going to be regretting that you didn't take the opportunity when it came.
I think that's really valuable advice for our students as well, and also gaining all that valuable experience for their CVs. But can I just say, you do have a great radio voice. So I think that everyone would agree here.
It's often said that, I have a great face for radio.
So we've spoken a little bit about the 70s. That's where you started your career in legal journalism, and then into journalism, then moved into legal journalism later on. If I can sort of fast forward slightly to the 90s, following New Labour's arrival in power, you commented that in one parliament there was more constitutional change than many had seen in a lifetime, and that was through devolution and then, of course, the Human Rights Act. What would you say has been the most significant constitutional change since that time?
We're talking about the Labour government of 1997, and Labour thought they were going to come to power in 1992, but Neil Kinnock didn't get elected, or the Labour Party didn't get elected under Neil Kinnock. But whether the Prime Minister was going to be Tony Blair as it was, or whether it was going to be John Smith who died, or whether it was going to be Neil Kinnock, they would all have chosen the same man as their Lord Chancellor, and that was Lord Irvine of Legg, Derry Irvine. And he had been planning a Human Rights Act for many years without people really realising it. And because it was all prepared and ready to go, and because they'd had a full start 5 years earlier, one of the things that was in the Labour Party manifesto for 1997 and in the Queen's speech shortly after Tony Blair became Prime Minister was a bill to incorporate the Human Rights Convention into the domestic law of the United Kingdom. And that went through Parliament very quickly in the first session. It was passed in 1998, it came into force in 2000. And that was significant, very significant. We know that two opposition parties are proposing to take the UK out of the Human Rights Convention and presumably to repeal the Human Rights Act, and we'll see what happens about that. But that was significant. As you say, there was devolution to Scotland and to a lesser extent to Wales, which was extremely important. And then we move on to constitutional reform. The other thing that Tony Blair regretted was Freedom of Information Act 2000, which he says he never quite realised the significance of at the time, and he was only Prime Minister, nobody told him. And as I say, we then go on to the constitutional reform and the legislation in 2005, which led to the creation of the Supreme Court in 2009, and the end of the role of the Lord Chancellor. Derry Irvine was sacked in 2003, and Charlie Faulkner was told he was going to be Lord Chancellor the following day, and that was a very interesting story as well. But no, all of that, and then the change in the role of the Lord Chancellor, the change in the creation of Department of Constitutional Affairs, Ministry of Justice, switching prisons from the Home Office, a lot of important things at that time.
And if you had to pick one of those, which would you say has had the biggest impact, most significant impact on the way our country is run?
Well, if it's the courts, I think it must be the Human Rights Act. Now, I mean, you could say that the development of the law of privacy would have happened anyway. I do say that because I think the courts are moving in that direction. But there's no doubt that the availability of the Human Rights Act and Article 8 gave a boost to the creation of privacy, which to some extent took over from defamation as the litigation of choice. So I think that did have quite a significant impact on the way the courts run. And I mean, one of the interesting theoretical questions is what would happen if the UK does pull out of the Human Rights Convention and the Human Rights Act is repealed? What sort of footprints would it leave in the sand? What sort of impact would 25 years and more of human rights law being absolutely fundamental to the way our courts work have on the common law, which is what would remain? Obviously, there's a question of what legislation might replace it. There might not be any, and it may never happen. But I mean, that is, I think, a very significant thing. You know, you can certainly say that a lot would have happened anyway, but it has given a boost to the development of the law.
Even with Article 8, so the right to a private life, that arguably doesn't stop, you know, the government in some ways eroding at that, one might argue. I mean, what are your views on the Home Secretary's plans to reform our system of asylum? What do you sort of think about those plans and the impact that might have on how we interpret Article 8?
I thought you might ask me that, and I have brought along the white paper published yesterday, Restoring Order and Control, a statement on the government's asylum and returns policy. And it's quite a hefty document. And if you look at the back, there's even an appendix summarizing the full set of reforms. Part 1, reducing arrivals. Part 2, asylum support and accommodation. Sorry, that's paragraph 2. Part 2, increasing removals. Part 3, safe and legal routes. And there's a lot in it. And it's had quite an impact. I suppose Shabana Mahmood is not too upset that she has been criticised by the left wing of the Labour Party and supported to some extent by the Conservatives. I think it will be very significant. You've got to consider, you know, to some extent the theoretical impact, because this is just a proposal and much of it will require legislation. We tried to find out when the legislation is going to be introduced and the government hasn't said. And we don't know how soon it will be. It could be quite soon, I suppose. It's certainly got the backing of the Prime Minister and the rest of the government. But, I mean, what impact does this have, the publicity that there's been over it? And the Home Secretary has generated a lot of publicity over the past 3 or 4 days. What impact does this have? Does this make people think that the UK is really going to make this place much less attractive for asylum seekers, for illegal migrants, as the government describes them? Or does it make them think we better get here quickly before it all changes? I think, obviously, the government is hoping the former, and if this goes through, I think it will deter illegal migration. I think it will have an impact, because obviously this country is very attractive to migrants at the moment.
Is there anything in particular within that you could say that would deter migrants or asylum seekers? Well,
the fact that, you know, you've got to have your case reviewed every 2.5 years, but ultimately you won't necessarily, excuse me, you won't necessarily be granted asylum for up to 20 years, which is quite a significant thing. So at the moment, you might get leave to remain after 5 years. So I will get my voice back. Good voice for
the radio voice.
So, as I say, at the moment, the government takes a view that it's really too attractive for people to come here. You know, they're housed, they're supported, and they are not able to work, but they are at least given support. And the government is hoping that this will deter them, knowing that they can't be sure of staying. Now, it's very unattractive to come here and not know whether you're going to be allowed to stay and whether you're going to have to go back. And one of the points put to Shabana Mahmood was that people can be here for 10, 15, 19 years and not know whether they're going to be able to stay. Her response to that is that if they contribute to society, then they can be given permission to stay here permanently rather sooner than that. But it's a very political issue, isn't it? It's a very political question as to, is she right in saying that there are too many people coming here who have no right to be here, and that this is damaging to society, and that we need to control borders and we need to deter people from coming here in small boats? Or are her opponents right in saying that these are people who are suffering persecution in their home countries, and we should be providing them with a safe and decent home? And that's a political issue rather than a legal issue, but there are some very interesting legal issues relating to it.
Sort of picking up on that collision of law and politics, I did want to ask you, if you don't mind, about Donald Trump's recent threat to sue the BBC. Obviously, as a former employee of the BBC, you may have some insider knowledge you can share. But really what I'm talking about is the threat to sue following the Panorama documentary, which was aired a year ago, where they spliced, if that's the right word, together 2 clips to give the impression that he was directly inciting violence at a march at the Capitol, a violent march. So he's threatened to sue, I think it's this week, because he made the threat last week, and he said he probably will do it sometime this week for between $1 and $5 billion. Firstly, do you think this is an empty threat? Do you think he will sue? And if you think he will sue, what would be the challenges?
When I spoke about this last week, I said optimistically that the BBC might even then be in discussions with his lawyer in Florida about settlement. And I was completely wrong about that, because the BBC said at the end of last week that it had decided to tough it out, that it had a good defence to his claim, and they wanted to bring it on. Now, they had also said that they were going to apologise, as he'd requested. Samir Shah, the chair of the BBC, wrote a personal letter to the White House apologising. They wrote to his lawyers saying sorry, and they withdrew the programme in the sense that it can't be seen again. So they satisfied 2 of his 3 demands. Now, in his original letter, he certainly said that he was going to sue for $1 billion in the way that American lawsuits seem to be fashioned. I mean, we do not say in this country how much we are suing for, generally speaking, because we take the rather old-fashioned view that that's a matter for the courts rather than the claimants to decide, and that also depends on winning your case. But Americans do seem to name a figure and say that's what they're suing for. And as you say, he then put that up to $5 billion when he got the response of the BBC, which wasn't as headlined by the BBC on the BBC's website. It wasn't actually, we're not paying compensation. It was simply that we don't think you, President Trump, have got a case. And the BBC was right as a matter of law in what it said. It said there's no proof that this program was seen in Florida. Now, again, I hadn't quite understood this when I first talked about this, because I was aware that stuff is available online, and in principle, if it's online, it can be seen anywhere. But the BBC, I said this on the Today programme. I don't often get on the Today programme, but I got the early morning slot on the Today programme about a week ago, and I said, well, it's available on BBC iPlayer, it can be seen anywhere in the world, and so on. And for the first time, within a few minutes, the Today programme announced after the next interview that this was wrong, because it wasn't available in the sense that BBC iPlayer, which is a streaming service, is not available outside the United Kingdom, which I know, and many people know, because they try and get around it by using a virtual private network, which works up to a point. So it may have been seen in Florida after all. And it wasn't available on any of the BBC's international channels. But it does seem to be the case that very few people, if any, saw it in Florida. And there's certainly no evidence produced by Trump's lawyers that it was seen. So that's the first challenge. Obviously, you've got to show that it was seen by people in Florida who who would be the people, he says, thought that his reputation was lowered as a result of watching this broadcast. And that's the other problem. He's got to show that it was defamatory, that it damaged his reputation. And of course, a week later, he went on to win the US election and did perfectly well in Florida as well as in other states. And so, again, the BBC is saying, well, prove that this was defamatory, prove that somebody saw it and took a different view of you as a result of seeing this, having not thought of you in one sense, but having thought, oh, well, if he said this and if he encouraged people to go and riot 4 years earlier, well, we will perhaps no longer vote for him. And that's all quite difficult to prove. So, from a legal point of view, if you're a student writing an exam, does he have a case? You'd probably say no. But if you're a practitioner trying to work out what the best thing to do for your client is, you're a lawyer advising your client, do you really want to fight President Trump in Florida? And who's going to pay? And what's it going to cost? Surely it would have been better to offer him a relatively small sum of money last week, which is what he asked for. He asked for $1 billion, but he also said in his lawyer's letter, that he wanted compensation, appropriate compensation, I think was the phrase. So maybe if they had groveled him as they did and withdrawn the program as they did and offered him, a significant but not huge sum of money to him or to a charity of his choice, maybe, possibly, he would have decided to leave it there, bank it and move on. Probably less likely, but, worth a try. And is it conceivable this week that having, talked tough, they are talking to his lawyers? It's the sort of thing lawyers do, isn't it, on behalf of clients? They say, can we settle this? Can we do a deal? Because once he issues proceedings, what's going to happen? They may come to nothing and both sides may walk away without paying anything to the other side. Certainly if the BBC were to win, it won't get its costs back in the US. And if he wins, he'll want his costs paid by the BBC. So it seems to me that if it goes to court, it's eventually going to cost the license payer more. Now, all right, the license payer doesn't want to pay anything, ideally, but it may turn out to be more expensive in the long run than offering him a small amount of money to go away last week, which we'll see. Now, a lot of people are very pleased that the BBC is defending its journalism. Great, fine, but of course it's not, because it admitted that its journalism was bad. So, it apologized for this. So why is the BBC willing to fight this, as it appears to do by, saying to him, well, we'll put you to proof and see you in court?
It is true. There is a bit of a inconsistency there in the apology and the denial in the same strength. But do you think the fact that the BBC is publicly funded will trouble Donald Trump when he decides whether or not to sue?
No, I don't, because he doesn't think much of that sort of commercial model, does he? Non-commercial model. He would say, I'm sure, that this sort of thing isn't appropriate. Why should people pay a tax to watch television? That's what commercial television is for. And indeed, why shouldn't politicians be allowed to advertise on television in this country as they can in the United States? What's so special about the UK? Why can't we buy advertising on commercial channels? Vote Trump or whatever it may be, vote Farage. So I don't think he may be sympathetic to the king. He may be reasonably polite to the Prime Minister, but I don't think he has any great respect for the BBC.
No. So this may be a move to bring the BBC down.
Well, it's not going to bring the BBC down, but it is going to keep the story in the public eye if this does go to court. Yes, the BBC may at the end of the road say, great, but don't forget this is decided, as I understand it, by a jury in Florida, which is a very strange thing from our perspective. It's fine to have juries for major criminal cases, but not for civil claims. particularly awarding damages where they seem able to pluck a figure out the air. Now, we did this in this country until quite recently, till the Defamation Act effectively abolished juries in defamation cases. And juries did come up with outrageous figures to begin with, and then they were given guidance and then they were scrapped. And I think it's very difficult to expect a jury to decide this sort of thing now. In the United States, as I understand it, they're often overturned on appeal and so on, but that all takes more time and costs more money. So, you know, if I were the BBC's Florida lawyers, I'm not sure I'd be too comfortable.
I don't think we have much. We have a time for a few more questions from me, maybe just one, and then I'm going to throw it open to the audience to ask some questions. But I suppose you mentioning juries did prompt me to want to ask this question. So Brian Levison, of course, mentioned already that he came here last year. He's completed his review of the criminal justice system, and he's highlighted delay really as the major factor that has put the criminal justice system in crisis, as he said it. Do you agree with that assessment? And also, what do you make of his proposals for reform?
I do agree with his assessment. Now, whereas David Gauke's proposals on prisons have been accepted by the government and have now got through the House of Commons and have reached the House of Lords and presumably will go through without too much difficulty, Brian Levison's proposals have not yet been met with a response from the government, from the Ministry of Justice. That's partly because he hasn't completed part 2 of his report, which I think comes early next year, and partly because the whole issue of limiting the availability of juries is controversial. The criminal bar wants to keep juries as they are at the moment in many cases. The government is presumably considering whether to take on the criminal bar and much of the legal profession. What Brian Levison is proposing is that some cases currently decided by juries would be decided either in the magistrates' court or in a division of the Crown Court comprising a judge with 2 magistrates. But either way, people would lose the right to jury trial for certain low-level cases. And when people say to him, as select committees do and critics do and so on, but we're very wedded to jury trials, he tells them that the availability of jury trial has been progressively reduced. He tells them that 90%, 95% of cases are tried in the magistrates' court. He says, why should the defendant have the choice in cases that can be tried either way of having a case tried by a jury? Why shouldn't the court decide whether it's serious enough to be tried by a jury? And ultimately, he says, if you've got cases currently being scheduled for trial in the Crown Court in 4 years' time, that's not justice at all. Justice delayed is justice denied. And given where we are, the only way of speeding up trials of important cases in the Crown Court and stopping them collapsing because the witnesses disappear or lose patience or die or something like that, go abroad, the only way of speeding up trials of important cases, rape cases, murder cases in the Crown Court, or others where Parliament has rather stupidly granted the right to jury trial, like an assault on an emergency worker. The only way of speeding up these cases is to have fewer of them. And he's right. I mean, there's no other way of doing it. So I'm sure he's right. I'm pretty sure the government will accept this. And we wait to see exactly what it goes for. He says his measures are a package. He doesn't want a pick and mix approach, but it's not up to him. But he's not saying that, you know, you can't do some of them rather than others, but he does say there's a coherent package there. And we're waiting to hear what the government's going to do. And I imagine we'll hear quite soon.
He's built a very logical case for it, and one that you agree with. Why do you think that the bar are against the proposal?
I don't think it's self-interest, although I suppose that may be at the back of people's thinking. I mean, they've got, the criminal bar has got all the work it can possibly cope with and more, so it can't be that. I suppose they think that the principle of being judged by your peers is an important one. And we used to have the principle of lay magistrates, a few stipendiaries in London and large cities where you couldn't get lay magistrates. But until the growth of district judges, district bench, you were either tried by lay magistrates or by a lay jury. And that was a very fine principle. But it has been eroded partly because of the erosion of the locality of magistrates. I mean, magistrates' courts, certainly in London, have combined, so you're less likely to be judged by somebody from your community in a big city. And partly because the pressure on lay magistrates and the wish for the government to get through work more quickly has led to the increase of district judges, who, of course, have more power than any other sort of judge because, they're judges of fact and judges of law, and they sit alone. So they're very powerful. So, you've had all of that. And I think, there is a concern that perhaps district judges are too powerful and that, it's quite important that there is this lay involvement in the criminal justice system. And everybody would agree that serious cases should be tried by juries. But given that so many cases are not tried by juries, does it really matter if we chip away at some of the cases that are, if the prize is that serious cases are tried before everybody disappears, before, especially if the defendant's remanded in custody. All right, those cases are heard more quickly. But it seems to me that this is the only way to get around the problem that the present government has inherited, which is this extraordinary delay because of lack of capacity.
That is definitely a logical case for that. I had to press you as an ex-criminal lawyer, defence, I should say.
You should tell me I'm wrong. You must take me to task.
Well, I don't think you're wrong, but I just question, this idea that the most serious cases will be tried by juries, and that's very sensible. But a theft, for example, can seem like a minor offence, but can end up with huge consequences.
Of course,
for later life.
Of course it can. And to be fair to Leveson, he's not saying that all thefts are going to be tried by magistrates. He is saying that there should be discretion, there should be choice. And there are, absolutely, if you have a person of good character, then a conviction for theft or any other offence of dishonesty is career-ending, no doubt about it. On the other hand, if you have somebody with several convictions for theft or dishonesty already, it's not going to be career-ending. I'm not saying that they shouldn't get justice and they shouldn't get the right verdict. I'm not saying they should be judged on past convictions. But, I think there is a difference, and I think he does well. He does as well.
Thank you. Right, so I think I've got time for one more question before I throw it out to the audience. We've seen the AI, the launch of AI, I suppose, that has taken many people by surprise, the speed at which it's been developed and then applied. We know that there is a crisis in access to justice. It's pretty much accepted across the board. Do you think that, and obviously we're really keenly aware of this being a law clinic, do you think that AI could be part of this solution? What's your view on the role of AI in the legal system and the justice system? Do you have any concerns about it?
Yeah, AI is very important. The reason that I'm getting out my laptop is I spotted a case this afternoon, which if I can find it, I'll read to you. Not the whole case, I assure you, but nevertheless, I will tell you what it said. And if I can't find it, I'll remember it. The approach of Sir Geoffrey Voss, the Master of the Rolls and Head of Civil Justice, is that AI is a tool like any other tool, and in the right hands it can be very useful, and in the wrong hands it can be disastrous. He compares it to a chainsaw. He compares it, I can't remember the other example, but there are things that you can use safely and well if you know what you're doing, and things that can cause a great deal of damage. And his position is that judges are allowed to use AI for research, perhaps even the first draft of a judgment, but nevertheless, they must be extremely careful because they are responsible for what they publish as judgments, and therefore, if something has gone wrong, then they must be answerable for it. The judgment that I saw this afternoon, I looked at it immediately because one of the parties was Birmingham University, and I thought, oh, this is about students, it was also headed contempt of court. I thought that's exciting as well. And the judgment was an exemplary judgment delivered and then transcribed at the request of the judge. And I think it was a district judge in the county court. And what it wasn't very clear until you got halfway through the judgment what this was about. But once you got through, you discovered that this was about somebody who had used AI in pleadings. And the consequence of this was that this particular lawyer was in trouble. It was said by the district judge that surely he saw the case last summer of this law centre person, very inexperienced, who didn't quite understand that she was using AI and thought that the cases that AI had come up with were real cases rather than hallucinations, and put these to the court. And I think there was some sympathy for her because she really had not been properly supervised in any way. And she had, it was quite clear that the law centre for which she worked was simply unable to check her work in the way that it should have done. She had no idea that what she was putting to the court was fantasy, false cases, and that these didn't exist at all. And we felt a bit of sympathy for her. But the problem was that this case, which a lot of us reported and which you'll be very familiar with and all your students will be extremely familiar with, didn't quite reach this hapless solicitor who put forward the case that he was involved in and used a particular software that he thought he'd used for ages and had no idea was based on AI. And in the end, he wasn't referred to the regulator, although that had been a threat, and he wasn't found in contempt of court, although that was a threat. But he was liable to costs. He will, I hope, know. I don't know how much this is going to be reported tomorrow because it's not a terribly dramatic judgment. But it is a very, very cautionary tale, which is that you have to understand the limitations of AI. You have to understand what it is. It's great for doing your research. It's great for preliminary work, but don't rely on it without checking it.
And you would extend that to students and the wider profession, given that was a solicitor in the most recent case with Birmingham University. Was that a solicitor acting for Birmingham University?
No, I think he was acting for somebody who was I think it was an employment case against the university. I will find it while you ask for questions from the audience, which I will listen to while doing my research. I'm capable of doing two things at once. In fact, three things, as you saw when I was talking to somebody earlier and spoke to you and pretended I wasn't listening to.
And realised I can open a door properly.
Journalists have to be able not only to read documents upside down on people's desks when they're sitting opposite them, but they have to be able to listen to at least two or three things at once. As you know, newsreaders have to listen to what's going on in the gallery as well as speaking, and we do learn how to do that sort of thing.
While you're multitasking,
exactly.
I will throw questions over to the audience. So just stick your hand up if you have a question for Joshua Rozenberg. And we have some roving microphones. So yeah, please be brave. So yeah, okay. Thank you. And actually, I know who that is. That's Paul. He's Logan or Will, do you want to pop up to Paul? So if you just wait for the microphone before you start speaking. Do you have the roving microphones? Oh, you rather make roving microphones. There you go. That's it. There you go. And then walk up to the. Is that okay? Go up to Paul. Okay, that's it. Yes, if you introduce yourself at the start and then ask the question.
Hello, Joshua.
Hello.
I'm Paul Whittingham. I'm one of the lawyers who helps with the Legal Advice Centre. I've got to mention earlier on. So I can review the letters the team of students produce after seeing their clients. So I should just say before I ask my question, my wife sitting next to me is a big fan of your Substack and uses it a lot when she teaches A-level law at a local high school. My question is, there's an expression that when America sneezes, Britain catches a cold, and the sneeze that I'm thinking of is the current administration at the very kindest pushing the boundaries of what is permitted by the executive branch under the Constitution, and there are various law cases going through in America. Most conspicuously at the moment, the one as to whether the tariffs that have been imposed are actually permissible at all. I rather nerdily listened to some of the lawyers in the Supreme Court a week or two ago just arguing the toss on this. From where you sit and observe, do you think that the sneeze in America has any danger of becoming a cold in Britain, that our unwritten constitution is under threat either now or in the past or in the future from an executive willing to ride roughshod over our, the rules of our unwritten constitution? I'm thinking also 2 years ago that Lady Hill talked about the invalid prorogation of Parliament, for example, but I just throw that out as an example.
Yes, which she managed to overturn. And interestingly, as soon as she and the Supreme Court that she then headed said this, Parliament returned, showing how our uncodified constitution works. There are risks to the rule of law here in the UK, and they are quite significant. There are risks in terms of lawlessness at low level, people seeing criminals breaking the law and getting away with it, people raiding shops and dragging everything off the shelves and running off with them and not being caught, or just low level crime, vandalism, that sort of thing. There is concern that attacking judges, both physically and that sort of thing has happened, and certainly in terms of their reputation, is damaging to the rule of law. And politicians have found themselves in that position. So there are concerns that the culture of the rule of law is under threat in this country, and it's obviously very important to preserve the rule of law against threats which you might not think of as threats, but which are threats nevertheless. Once you undermine the judiciary, everything seems to fall apart, and we rely on the rule of law for things to work. And the example we were just talking about of the delays in the Crown Court and in the County Court is very worrying, because if people feel they can't resolve their problems through the legal system, then anarchy is what follows. So, there are concerns. Now, I say that because we shouldn't be complacent. I'm not sure that the same system applies here as in the United States, and I'm not sure that one can draw such a close analogy. I mean, it is very interesting, isn't it, to see how much President Trump is able to achieve by executive orders, because that's not something that we do here in this country, is it? We certainly have given ministers powers, very wide powers, sometimes powers even to, reform acts of parliament, Henry VIII clauses, as they're called. But nevertheless, we do limit the powers that we give ministers, and certainly the powers we give to the Prime Minister. And if you talk about the prorogation case, which was Miller 2, that takes you back to Miller 1, which was the question of whether legislation was needed to trigger Brexit. And the then Prime Minister, Theresa May, thought that she could trigger Brexit without the need for legislation, and it turned out that legislation was required. Now, there's no trouble getting the legislation through, but nevertheless, the courts said that legislation was required. And if you're looking at the US, it's very interesting to see how far the courts are prepared to go along with the president, and when the Supreme Court, in particular, will hold the line, draw the line, rule against him. And obviously, if you look at it in terms of politics, the Republicans have a majority on the court, but I think John Roberts, the Chief Justice, is sensitive to all of that. And I hope that at some point we shall see the courts simply saying that what's proposed, and I'm not referring to anything specific, is unlawful, as the courts did in the 2 Miller cases, as the courts do every day. Quite how that's going to play out, I don't know, but I suspect that people here who are watching what's happening in the US are quite sensitive to that. And I'm pretty sure that the judges here are determined to maintain the law in a way that we wait to see whether the US judges are going to do.
Thank you. Very insightful question, and obviously a brilliant response. Any other questions from the audience? Yeah. And that's Graham, I think, as well. Yeah. But yeah, if you introduce yourself first, and then once you get the microphone.
Thank you. I'm Greg Sharp. I don't have a legal background. I'm a welfare rights advisor. And the question I'm asking, really, I think all of us against is just given, but one of the main criticisms of the Human Rights Act is that it's too easily abused by activist lawyers. And I'm wondering how you think, or whether you think, the legal profession can and should respond to that.
Well, obviously that's something that the government is seeking to do, and something that the government is seeking to do through legislation. We haven't got the details of it, but they say that Article 8 is a qualified right, which means that interferences with it can be justified where it's proportionate in the public interest. And they say that that balance between the individual's rights to private and family life under Article 8 and the public interest needs to be reset. They will legislate to ensure that the balance is properly set, and that would narrow the circumstances in which an individual's Article 8 rights would outweigh the public interest in removing them. And the way in which they're going to do that is by narrowing down the definition of family, by stopping people making Article 8 applications from abroad, and other similar restrictions. Now, this goes to domestic legislation passed by Parliament here, which of course is binding on the courts, and the courts, I'm sure, will enforce that legislation if and when it's passed. This is only a proposal, we wait to see. It's perfectly proper for lawyers to represent the interests of clients within the law as it currently stands. It's perfectly proper for them to push the boundaries and see what the law will allow. It's perfectly proper for them to act in the interests of their clients. And the answer is that if the government thinks that the law is not serving society, it asks Parliament to change the law, which is what it's proposing to do. So that's all perfectly legitimate. And crucially, says the government, it's something that can be done here in the UK through Parliament without pulling out of the Human Rights Convention. And that's where it differs from the Conservatives and Reform UK. So I don't blame lawyers for using the law. If the law is there and they must act in the interests of their clients, that's right. I wouldn't call them activists. Activists perhaps means campaigning for changes in the law. That's also perfectly legitimate. But activists, to some extent, is a term not of abuse, but is a slight insult, because they would say they're simply acting in the best interest of their clients. And that in itself is legitimate. Obviously, if they act unlawfully, if they mislead the courts, they get into trouble and their clients don't benefit. But provided they put their client's case honestly and fairly and accept what the courts do, then that's within the role of the lawyer. But as I say, if we, the country, or they, the government, don't like any of this, then the answer is to change the law.
Thank you. Any more questions that I can come to in the audience? We have got time for another question. Yes, and it's to Chris.
Chris Oliver-Birch, Solicitor of Actions and Actor at University here. So, product liability claims in the States. We've talked a bit this evening about across the Atlantic, the differences between the legal systems. And in the States, there are product liability claims being brought against social media companies. None of them, I believe, are successful, but we have similar laws here of negligence, which enable you to bring a claim on the basis that the company is putting out a product that's unsafe at any speed. It's inherently dangerous. The algorithm is, for a number of reasons, seeking to entrap people. It's dangerous for society. Much like a sort of lawnmower, which has no cover for the rotary blade. It's just whatever you do with the product, it's not going to be safe for society. Now, none of these claims are successful. I just wonder whether you think, if there might be success in the States against one of these big companies, given Trump and his support for them, and equally, if they were successful over there, something similar could happen here, whether we could take those companies.
On the specific thing, I think a lot depends on cost shifting. I mean, we say that the loser has to pay the other side's costs as a matter of principle, which I don't think they do in the United States. So I think that deters speculative and false claims. Conversely, we are currently developing a class action system through the Competition Appeal Tribunal with an opt-out thing whereby people who may have been damaged by large corporations overcharging for a particular service are able to recover through a class representative and with the help of a litigation funder. And I'm thinking about the MasterCard case, which settled for only 200 million, but billions were claimed. And now the funder is challenging that through judicial review, not so much the settlement, which they can't do anything about, but the way in which it's to be distributed on the basis that not enough is going to them and too much is going either to the members of the class or to the charity that's going to benefit if there's any unclaimed damages. I think these are all difficult questions. We do want consumer law to ensure that products are safe. We don't want large organizations to produce products that are unsafe, pharmaceutical companies, mechanical companies, whatever it may be. Equally, we don't want innovation to be stifled by lawsuits which people feel they need to settle on a nuisance basis and end up paying a lot of money for. I think these are questions of balance. I take some comfort from the fact that we do not have such a commercial system as they do in the US. Yes, law is expensive, and yes, you should avoid litigation like the plague. But it is still possible for litigation here to resolve cases fairly. It is possible to some extent for these class actions to be resolved fairly. There were 1 or 2 cases that were thrown out recently for various reasons. And it is possible for consumers to benefit from what's being done on their behalf. And it's possible also for litigation funders to make a profit for their investors. I'm not saying things are working perfectly here, far from it, but I don't think we are as litigation crazy as they seem to be in the US. I think there are some checks and balances. I think things are a little bit calmer here, and I'm rather pleased about that.
Great question. Just picking up on what Chris said, actually, in relation to social media companies, do you think that this same consumer protection is going to be or is necessary for artificial intelligence? I ask that simply because we have no changes to our regulation in relation to using existing legislation to regulate it. Are there dangers there?
Well, there are dangers. But then who are you regulating and how are you regulating it? I'm not sure. I mean, you can't control the development of AI as such, as far as I can see. We can all fantasize about AI being bigger than you are and coming back and hitting you in some strange way. But we can regulate the people who use AI, in particular lawyers, and lawyers are regulated. And regulators are considering what needs to be done when lawyers misuse AI. And I can't find this Birmingham case, I'm afraid, but it's somewhere hidden away there. But the principle is there, which is that lawyers who waste court time, who misuse AI, are on notice that they are going to be in trouble with their regulators. And I don't think it does their reputation much good either. And the same applies to judges. If judges take shortcuts, they're going to be criticized by appeal judges and by journalists and by everybody else. So there is a sense in which users of AI who are professionals are on notice and are subject to regulation and need to be careful about what they're doing. I'm not sure you can do very much about the inventors, and I interviewed an inventor last week who was slightly more critical of AI than I think the company that had paid him $650 million for his product wanted him to be. But there you go. That's public relations for you. It was their suggestion that I should interview him. And there we are. He's more of an inventor than a PR person, I'm afraid, even though he trained as a lawyer. The podcast is on my website, if you like. But it's behind the paywall. And there are problems with this, and we're coming to grips with it. I mean, it is extraordinary what it can do, but it's also very important to understand that it's only a machine, it's only guessing, it's only speculating on what the answer should be. It's only, working out what words follow what words. It's not real. It's not human. It doesn't have judgment. And it gets things wrong. And it's plausible. I mean, it's very easy, ask AI about yourself. And most of what it tells you will be right. Some of it will be repetitious. Some of it looks plausible, but will be wrong. Some of it's nearly right. Even now, there's a new AI version of Wikipedia, and obviously I looked myself up on it, and most of it was right. Some of it was repetitious, and some of it's out of date. Well, it would be because things change. So don't rely on it.
No,
but make use of it.
I suppose the question wasn't really necessarily directed towards lawyers, it was to the consumer using an AI tool as a legal advisor in an unregulated setting.
Well, there's one basic piece of advice which is very, very simple. If you Google something, the first answer you will get is AI generated. It's a summary by Google of the answer to the question it thinks you've asked. And you can glance at that out of curiosity, but you should then move quickly on to the next entry, the next response, which will be a link to a web page. And then you look at that web page and you use your skill and judgment to decide whether that is giving you an accurate and plausible answer to your question. And the chance, I mean, that may be written by AI. Years ago, a lifetime ago, almost 2 years ago now, I mean, a really long time ago in the system of AI, I got a press release from a law firm. And, you know, it quoted a partner at this law firm, and it quoted a judgment, and it said this judgment was from the UK Supreme Court. And I thought, no, it wasn't. It's from the Court of Appeal. And as far as AI is concerned, Court of Appeal, Supreme Court, they're all courts, aren't they? And yeah, this has been attributed to the partner. Now, all right, it may have moved on since then. As I say, it was a lifetime ago by the standards of AI. But, you know, you want to look at the original source material. And we haven't talked about, you know, the decline in journalism and the difficulties of people finding out what's going on. But the one bright spot in journalism, and this applies to law students particularly, is the availability of primary sources, which means that even if you don't have access through a university to the big publishers like LexisNexis and Thomson Reuters and others, you do have access to cases which are publicly available. You have access to statutes which are publicly available and updated. You don't have the commentary, you don't have the explanation. And you have access to Hansard, so you can see what was said in Parliament, except, of course, it's not exactly what was said in Parliament. Although if you look at what Shabana Mahmood is saying, it does tell you exactly what she said yesterday, even if the newspapers feel a little sensitive to their readers and don't tell you exactly what she said in Parliament yesterday. So Hansard is, but that, of course, tries to make sense of people speaking in this unstructured way that I'm speaking now, and tries to turn people's remarks into accurate sentences and tries to make them look good. So it's not a perfect record, but the audio's there and the video's there. So there are primary sources. So if you're not sure about something, don't rely on the first answer on AI. Look and check and double check and see if you've got other sources. And, you know, just be skeptical.
I think that's a perfect point to wrap up on, where you have told our students to be rigorous in their research, to go to statutes, Hansard and case law, and thank you for that. So that's an excellent place to stop. So if we could all join me in a round of applause, say thank you to Joshua Rozenberg. So all that leaves me to say is please don't leave the building, because we have wine and canapes to enjoy. There's several lawyers here and also law students and members of the public. So I really would encourage you to network and meet one another, discuss. I'll be milling around too, so please come and say hello if there's anything you want to talk about. But thank you very much for coming, and see you for a glass of wine.